All right, it looks like the registration count is stabilizing, so we're going to go ahead and get started. This is a webinar on the FTC non-compete ruling. This is a follow-up to a legal webinar we did on our last one. And so lots of change going on in the lab industry right now, regulatory change that affects how you run your lab, and whether you work in a laboratory may affect you directly. And so we thought this would be good content to bring forth in a timely manner for you to understand the impact it might have on your laboratory. We're excited that we got the best of the best to come talk about the topic. So we've got Robinson Coles, Danielle, Tangorre, and Levinson to share their expertise. Danielle has extensive experience counseling clinical labs, healthcare providers, behavioral health providers, hospitals, and other healthcare entities to navigate operational and compliance issues and assist with business transactions. Danielle takes a holistic approach to helping her clients achieve their business goals with a regulatory maze of federal and state laws. Danielle regularly advises clinical labs and other healthcare entities with respect to federal and state fraud and abuse laws and billing compliance. I know she's real strong on New York. She routinely represents clients before federal and state agencies related to healthcare enforcement investigations and audits. And she parents a 1- and 3-year-old at the same time somehow. And Les is co-chair of the firm's Transitional Health Law Group, member of both the Health Law and Business Transaction Group. He's represented private and public businesses throughout his more than 30 years and has completed more than 400 M&A transactions. Although Les maintains an active business law practice, he concentrates on the transactional, regulatory, and compliance representation of healthcare and life science clients, including home care, hospice, behavioral health, physician practices, hospitals, information technology, med device, healthcare equipment, and of course, lab as well. He brings a proactive approach to problem solving, assists clients by anticipating issues and implementing creative, cost-effective strategies and solutions, and is a pretty decent guitarist and a member of a band as well. So we're happy to have both of them on with us today. Before we get started, we'll go through a couple housekeeping items. If you're having buffering issues, make sure that you're closing any apps you might have open or other tabs that might be sucking up some of that bandwidth. Our number one question every time is whether we're going to record this webinar and whether that you will be able to get a copy of it. The answer is yes to both, and you don't need to do anything. So if you registered for this webinar or you're hearing my voice, you're going to get an email with a link to the entire presentation. So that'll come to you automatically, no action required on your part. We will take some Q&A. So on your right-hand panel, you'll see that there's an opportunity to click on that Q&A and enter a question. We will be kind of moderating those and trying to group questions into like questions. And we hope to have a few minutes at the end to be able to get to those. And then we'll always give you an opportunity to connect directly with our guest speakers to go deeper on customer-specific questions. We're going to run a couple polls today. You'll see those pop up on your screens. We encourage you to engage in them. That's how we have feedback, and our guest speakers can hear from you on what you're seeing out there. So keep an eye out for those. A little bit about us, Lighthouse Lab Services. We do this as a free service. We don't charge anything. The way that we're able to do that is by continuing to provide services to clinical labs. We're a clinical laboratory consulting and recruiting firm. We've made some recent acquisitions. Our most recent was of ABS down in Texas. And with that acquisition, we've brought on a full team of field service engineers to provide instrument service, doing PMs and providing third-party service contracts for those so that you guys can save a little money on those OEM contracts, parts as well. And wanted to give you guys as a webinar attendee a special offer today. So we're going to give you a free month of service. There should be a opportunity for you to respond in the bottom left-hand corner of your screen. If that's something you're interested in, you have some mass specs, immunoassay equipment, we'd love to give you a quote and see if we can save you some dollars and also improve the turnaround time on instrument service. So we're going to go ahead now and bring in our guest speakers, Robinson Cole, to speak about the FTC's non-compete rule, and I'm going to turn it over to Les.
Good afternoon. Thank you. Looking forward to today's presentation. Let me just flip ahead to our agenda. So we have a pretty fulsome agenda today. We want to go through a summary of the key provisions of the rule, talk about how it's intended to work, who's covered, some of the key definitions, of course, the exceptions to the rules, how this applies to the lab industry, some suggested alternative solutions. There are some pending challenges to the rule, which are quite important. So we want to focus on those a little later in the presentation, and then talk about next steps for our listeners. So let's dive right in to a summary of the key provisions of the non-compete rule. So briefly, it prohibits employers from entering into new non-compete with workers on or after the effective date. We'll talk about the effective date in a moment. It prohibits employers from enforcing existing non-competes with workers other than senior executives. It prohibits employers from representing that the workers are subject to a non-compete. And importantly, the rule is intended to take effect on September 4th, 2024, but this may change depending on the outcome of pending litigations that we'll talk about a little later in the presentation. So the non-compete, let me get to the next slide. So it's really truncated into two categories: workers who are other than senior executives, and we'll get into the definitions of who they are, and senior executives. So in that first bucket, the ban prohibits employers from entering into or attempting to enter into a non-compete, enforcing or attempting to enforce non-compete clauses, and also a requirement to notify workers who are subject to a non-compete clause. And Danielle's going to talk about that a little bit later in the presentation, and also go over what the content of the notice should look like. So with respect to the other bucket, for senior executives, the ban would prohibit them from entering into a non-compete clause after the effective date. So there is a little bit of a grace period between now and September 4th, assuming that that date continues to hold. So broadly speaking, who's covered? And effectively, we're talking about most private for-profit businesses, which is clearly inclusive of the laboratory industry. There are some exceptions, which are outlined on the right: public entities, not-for-profit entities that meet certain definitions, and other industries that were carved out from the FTC rule. But generally, those are not going to be of major concern for our purposes here. So let's talk about the key definitions that are embedded in this rule. Not a surprise, they're broad. They're intended to encapsulate the entire rule, and they work together. So the first one we want to talk about is a business entity. And what does that mean? It's a partnership, it's a corporation, it's an LLC, it's a division, it's a subsidiary. Effectively, it's almost every type of business entity and organization that you could think of. What's a non-compete clause? It's a term or condition that prohibits a worker or penalizes that worker, or functions to prevent that worker from essentially accepting a position elsewhere. Again, very broad. The next definition, which is important insofar as a later definition for senior executives, is policymaking position. And that means a company's president, its CEO, or any other officer who has policy-making authority within that enterprise. Just really a couple more key definitions. Policy-making authority is the authority to make policy decisions that control significant aspects of the business entity or the enterprise. And an officer is a president, vice president, secretary, financial officer, controller, or other folks who are performing similar business functions. So now we get to that kind of second bucket definition. We were talking before about workers who are not senior executives, and then we're going to talk a little bit about who senior executives are. And the definition was kind of crafted to tilt towards more highly compensated individuals who perform decision-making functions, but query whether that number that you see there, is really a meaningful demarcation in our current economic climate. So a senior executive is a worker who's in a policy-making position who received annual compensation of at least $151,164. And you can see that those definitions also relate back to the ones that we just covered a minute ago. So before we take up exceptions to the rule, which Danielle is going to cover to you, I just really wanted to briefly recap where we are so far. So the FTC adopted this new rule, which is now effective September 4th, unless it's pushed off, as we'll talk about a little bit later. And it's a broad prohibition on non-competes, which is really intended to apply very broadly across the domestic labor pool. Danielle?
Thanks, Les. So there are a few exceptions to the rule. As we saw in the buckets, currently there has to be, if the rule goes into effect, current non-compete clauses with workers that are currently in place no longer can be enforced. There is an exception, though, for senior executives, that current non-compete clauses with senior executives can remain even after the effective date. There's also an exception that even after the effective date, that you can have non-compete clauses as part of a bona fide sale of business. And a bona fide sale of the business means that that it's made in good faith between two independent parties at arm's length, and the FTC sees this as a seller having a reasonable opportunity to negotiate the terms of the sale. They're specifically excluding any type of springing non-competes or non-competes arising out of repurchase rights or mandatory stock redemption programs, saying that those are not bona fide, at least in the comments. This is a change from the preliminary rule that was put out, as there's no longer a certain threshold. Commentators noted that the prior 25% ownership threshold was too high. And so in any sale of business where owners, members, or partners with goodwill in the business are selling, then you can have a non-compete as part of that, with understanding that this is a unique, kind of a unique situation, has unique interest, and oftentimes the buyer is purchasing the goodwill and part of that person, members, education and business acumen, and so a non-compete can make sense here. There's also an exception that non-compete clauses that are subject to pending litigation are accepted. And just for clarity, the FTC noted that non-solicitation agreements and confidentiality provisions are not impacted, and we'll talk about those a little bit later, but we want to make clear that that they're not reading the non-compete so broadly to include all restrictive covenants. And then important to note that the FTC's jurisdiction is for work inside the U.S.
Hey, Danielle, it's probably helpful to note for the listeners that this rule was highly anticipated, and there were 570 pages of commentary that accompanied the preliminary rule before the final rule was adopted. So it's certainly been getting a lot of attention before the rule was adopted, and certainly with the ongoing litigation, as we'll talk about in a couple of minutes. No surprise, a lot of attention after the fact.
Yeah, that's a great point. And if you read all the commentary in the rule, the FTC took great strides in the final rule to talk about their authority as to why they're able to do this, how it is within their ability to enforce, and also took into account a lot of the comments and made some modifications to the rule, but also tried to focus on really, to some degree, a very broad ban on non-competes. So with the rule potentially going into effect on September 4th, there is a notice for those workers that are subject to the rule that you have to notify all workers that their non-compete and their contract is no longer enforceable and cannot be enforced. There's certain language. The FTC expects that you're going to provide clear and conspicuous notice to the worker of this and identify the person and the clause and be delivered to the person by hand, mail, email, or text message, which is a little bit unique. And so they provide multiple ways to do this to provide the notice. The FTC also provided a model notice, which we've included here, which the FTC has deemed sufficient if this is followed to notify all workers about the ban on non-competes. So what you guys all are probably waiting for is, how does this impact the laboratory? So first and foremost, you really need to determine who is a senior executive. The commentary of the rule spent a lot of time talking about senior executives and what this means. They carved out the definition, as Les talked about, with a certain salary threshold, but also with policymaking authority. But what does policymaking authority mean? The commentary sheds some light on this. It is going to be, kind of case fact specific, but factors to consider, as noted in the commentary, is that senior executives are most likely to, quote, have a bespoke and negotiated agreement. The thought is that these senior executives are going to have the bargaining power to negotiate in a meaningful way the non-compete, and are less likely to experience exploitation and coercion. The FTC spent a lot of time talking about the fact that there are high earning workers who may have titles and things of that nature who are not senior executives, and that they still face exploitation and coercion from the non-competes and don't generally bargain over them. And so they wanted to exclude those. That's why there's the threshold test of both the salary but also the policy-making authority. And further thoughts on who has policy-making authority. The commentary discusses that it's someone who has control over a significant aspect of the business entity without needing a higher level worker's approval. But they, made some examples. So, for example, if the head of a marketing division, they used a manufacturing firm, only makes policy decisions for that division, and those decisions do not control significant aspects of the business, that person is not a senior executive. They also the FTC made comments in the medical context more focused on physicians, because there was a lot of commentary about how physicians shouldn't have non-competes. But their example here was that the head of a hospital surgery practice, or a physician who runs an internal medical practice that is part of a hospital system, would not be senior executives, assuming they are only decision makers for their particular division and not for the business as a whole. So there is, some ambiguity about who is a senior executive, and it's really going to depend on the structure of your lab and the authority making decision. So with that, capturing that and the kind of the commentary, it's possible that the non-compete ban is going to apply to your sales and marketing team. There may be exceptions for, VP of sales and marketing and things in roles similar to that. If in the event that they have, decision-making authority that controls, the overall business. But again, that's going to be an analysis you're going to have to undertake. And it likely applies to scientists and other highly trained individuals in the lab, which is also important. There was commentary, again, about in the scientific field about, they used a specific example about a geneticist at a university founding a biotech startup to develop cancer immunotherapies. And they showed that this was illustrative that this person should not have, a non-compete because it artificially creates scarcity in a market for top scientific talent, and that's what the FTC is trying to prevent. They want healthy competition between industry and new entrants. And so you have to think about that when you read all the comments, as to who they're really trying to apply it to. So, at the end of the day, it's, the FTC is really trying to limit this to C-suite people who have that policy-making authority, viewing that even well-paid people might not have sufficient bargaining power to avoid exploitation and coercion. And there's a numerous set of examples there about people arguing for and against non-competes in the comments.
Yeah, so before you leave that, Danielle, I think just kind of following up that thought, assuming just for a moment that the rule survives and it survives in its current form, there's no moratorium, which, it's maybe not going to be the outcome here. That's essentially where the action is going to be, is determining the facts and circumstances of people who may be marginally senior executives, and that's really where the disputes are gonna lie, and it's going to be determined on the applicable facts and circumstances. Although the commentary was 570 odd pages, the actual rule was only 8, which is highly unusual for government rulemaking period. So it's a pretty straightforward rule with very, very broad definitions, and that's why you end up with an 8-page rule and 570 pages of commentary trying to explain what those 8 pages mean and giving a plethora of examples about how it may or may not apply. So I think the answer is, continue to stay tuned on that.
So there are some, alternative considerations if the rule does go into effect in September. It's really important to review your agreements, but confidentiality, non-disclosure, and non-solicitation clauses and contracts are generally permissible. The factor here is whether those functionally prevent an individual from working for another employer in the same field. They need to be tailored to protect the business interest, but the FTC is concerned that people may try to use these as a workaround to be written so broadly that they functionally prevent, that worker from being gainfully employed in the same field in the same area, which the FTC would be concerned about as being, a workaround of their rule. That's why, these are generally permissible, but they do can provide a lot of protection. And, the details are going to be in the nitty gritty about protecting, trade secrets and confidential information. And as we discussed, non-competes are allowed in certain sale of business agreements in that bona fide sales.
I think if you've previously engaged in a sale transaction, you'd be pretty familiar that a non-compete is pretty common in these types of transactions. You always have to check with state law to make sure that you're complying with applicable state law. Some states are more restrictive than others. I mean, California is one that certainly comes to mind, but the workarounds there that Danielle was talking about, confidentiality, non-disclosure, non-solicitation, well crafted, will even work in places like California. So these aren't new concepts, but they're ones that are going to become increasingly more important if the non-compete ban survives.
That's a great point, Les. And as Les mentioned, you always have to be mindful of state laws, as there is a movement in a lot of states to also ban non-competes, and that's a ever-shifting landscape. And now, Les, if you want to talk about some of the challenges.
I do. So thank you, Danielle. So not a big surprise. Within a couple of days of our rule coming out, the lawsuits began. There were two that were initially commenced in Texas, which is increasingly becoming almost a haven for business litigation. The two cases, Ryan and the Chamber of Commerce, were consolidated into the Ryan case, which is pending, and most are expecting a decision somewhat soon, whether it's the latter part of June or maybe after the 4th of July holiday. We don't know for certain, but we're expecting a decision there. And then there was another case that was filed in Pennsylvania, but most are looking towards the Ryan case to sort of set the stage for next steps on the litigation front. And what was sought in that case is a stay and a preliminary injunction, which means that basically the rule would be frozen until that injunction and stay are either lifted, or there's some other activity, could be a settlement of the case, or could be something on the merits. So let's turn to your next steps. I think I went too far. There we go. So obviously, the monitoring the litigation is going to be extremely important, because that could have a crucial impact on this September 4th implementation date. Our firm is going to continue to follow that litigation. We'll be updating it for whatever developments arise from it, and we'll be sending updates to our clients, colleagues, friends, interested parties. So stay tuned for those. Continue to sort of look at what's happening in the states, if there are any changes that come out of this as a result of the ban or other activity going on in some states. As many of you may know, a number of the states have been pretty active. New York was considering a non-compete ban, but in the final budget that was adopted recently, that did not survive. So that's just one example. You should, though, take stock of which employees might be potentially impacted by the rule, so that if you need to send out notices, again, assuming that that part of the rule or the rule itself isn't suspended, you won't be necessarily having to do a fire drill, but you'll kind of know who needs to get notice and what your notice is going to look like. The form of notice that was included in the materials a little bit earlier would be a good template for you to use with your own applicable information. And as Danielle was mentioning before, if you don't have non-solicitation and confidentiality agreements, you should consider implementing those. If you do have them, you probably want to take a look, particularly if they've been in place for a while, and maybe need to be updated and upgraded. And we would certainly encourage everyone listening to consult with your business, your financial, your legal advisors to make sure that those confidentiality and non-solicitation provisions are compliant and are effective to achieve the business outcomes that you need to address. So think with that, we do want to open the floor to questions. I know we had time reserved here, but we wanted to cover the highlights and make sure that we got that information across to everybody listening. So
yeah, Les and Danielle, really appreciate that. Thank you for a great overview and summary. If anyone needs to reach out or contact Robinson Cole directly to go deeper on anything specific, you need assistance with reviewing your non-competes or crafting new non-solicits, non-circumvent type agreements, that's what they're there for. They do it better than anyone. So you'll see on your screen there an opportunity to ask for some more info or connect with Robinson Cole. Encourage you to do that if you have some ongoing specific legal needs around this issue or other lab law issues. But we're going to dive into a few of these questions. One of the more common ones that was coming up was around non-compete, and non-solicit, non-solicitation, non-disclosure, kind of where that line lies. I know you guys covered it, but maybe just hitting one more time which of those areas is banned and what can be done, and maybe some of the other areas to accomplish a similar goal.
You want to grab that, Danielle? You want me to grab that? I mean,
sure, you can start.
Yeah. So I think as we were saying, you want to be making sure that in drafting these kinds of agreements, you're not effectively creating a non-compete in disguise. So if you look at the kind of information that you would expect would be confidential, I think it's more likely than not that type of information is going to be protectable, and your employee's not going to be able to go and take that off to another employer. If they've developed clients while they're in your employ, using your resources and information that you've provided, and then try to solicit those clients later on, that's probably an area that's also more likely to get favorable protection. If they came with their own list and they're leaving with their own list, maybe that's a different story. Confidentiality and non-disclosure, non-solicitation agreements have been around for a long time, so courts are familiar with them. And again, I think as long as you don't try to dress this up and disguise it as a non-compete, you're probably going to be okay.
Excellent.
Yeah, and I would just add, sometimes people get a little confused about the line between a non-compete and a non-solicitation. For a non-solicitation, those can be generally permissible. Again, it can't functionally prevent someone from leaving, but non-solicitations are generally less restrictive, and if you left, you may have a non-solicitation in that you couldn't poach other employees actively, but if they left on their own, and decided to come, that may be permissible, but it would be your act of trying to poach a whole group could be problematic depending on the language in a non-solicitation.
Yeah, and if you're using freestanding non-compete agreements, they very often would already have a non-disclosure, non-solicitation, confidentiality type provisions in them. So you may be able to extract those going forward and make sure that you tailor them appropriately, leaving the non-compete behind.
Great. That's a good clarification. Hopefully that answers. A couple people had questions, Scott. Hopefully that answered your question as well. Other questions we have are around, do like 1099 or contractors, does this apply to them? Can you guys speak to that?
Yeah. So if they would fall within the definition of a worker, which I believe that they would, then I'm not sure that distinction is going to make is going to make any difference. So I guess if we want to go back to the definitions from the slides, we can do that, but or you can look at that on your own. But a worker is a natural person who works or previously worked, whether paid or unpaid, without regard to the worker's title or worker status under any other state or federal law, including but not limited to your employee, independent contractor, volunteer, apprentice, sole proprietor, etc. So I think definitionally that category of individuals would be covered.
Great. How about the effect of, prior to this, there was certain states that were more non-compete friendly or really didn't recognize it. Is this going to supersede all of this federal, or is state distinction still going to need to be taken into consideration?
You're still going to have to pay attention to state distinctions. So if you take sort of the left side and the right side, meaning if you're dealing in a state that had no non-compete legislation and now there's a federal ban, then you'll only have to comply with the federal ban. If you're in a state that had more restrictive rules than even this federal ban, then you'd have to make sure that you're paying attention to those as well. So I think, as we alluded to in the discussion about non-solicits and that category, even if you can use them where you want to make sure that you're complying with the applicable state law, which could be a little bit narrower than the federal ban.
Great. Okay. One other question was about maybe some type of grandfathering or retroactiveness to this. Besides it's not in effect now, we know it's coming, if no earlier than September, it sounds like, but is there, can you speak to that, I guess, with these non-competes that were already in place? Are they going to stand even if they don't meet the exceptions, if they're signed earlier? I think you covered it, but maybe hit it again.
Yeah, sure. If it is for a general worker who's not a senior executive, even if it's entered into now, the rule is retroactive, and so in the sense that it will ban the continued enforcement of any non-compete for workers. So this is what's really important, is you have to determine who's a senior executive, because senior executives who currently have non-competes you're allowed to keep those non-competes after the effective date, but you cannot enter into any new ones. And then there's, of course, the sale of business exception we talked about.
Sure.
So you have a little bit of a grace, but you have to decide how much you'd really accomplish without it. And to Danielle's point, if you have existing non-compete with workers, you won't be able to enforce them after the effective date. So.
Right. Okay. What about this notice requirement? Is it explicit what the penalty would be? It seems like it's coming up pretty quick that employers will need to notify individuals whose non-compete is no longer applicable. Do we know anything about what the teeth is behind that if an employer fails to get to an employee or properly notify?
So the FTC will have jurisdiction, and it will be considered, in violation. So they would be able to enforce. And then, if a company tried to enforce a non-compete after the effective date, they would not, in the rule held, they would not be effective. And so depending on the contract terms, if you took them to court, for example, to a worker and said, we're enforcing this non-compete, and the rule stood, and you took them to court in October and they weren't a senior executive, and there was, reasonable attorney cost provision in the contract, you would be subject to paying the attorney's fees of the worker potentially. So, there is liability as to, enforcing this Les, I don't know if you have any other thoughts.
Yeah, I mean, we can address that in more depth after, but you could be subject to potential fines and penalties as well. So there is a little bit more teeth in the rule as well.
Okay. What about the notice? And I think you guys touched on this a little bit, but is a blanket notice to employees about this change sufficient, or it needs to be custom to the employee? I'm just thinking for companies that have a lot of employees and trying to track down who this applies to, who it doesn't, to be notified, which is a little bit different than the enforcement, but just making sure that they cover all their bases. Can you send a notice to all your employees, or does it need to really be individual?
The rule indicates that it needs to name the individual. So the overall notice, if you have, standard contracts, your template notice is going to be the same, but you have to name the individual in each of the notices, tailor each of the notices to that.
Yeah, I think that's important. Another question that came up was, is there any correlation with ECRA? Are these things totally separate? I know that a lot of salespeople are affected by the ECRA rules as well as this non-compete, but are they joined in any way, or any type of correlation we should be aware of?
I don't think there's any correlation. It's just yet another regulatory requirement that you're going to have to consider when you're dealing with your sales reps, but ECRA's a totally separate consideration.
All right. Well, I think that will cover it for questions. I'm going to push that contact form one more time. If you need to reach out to Robinson Cole directly to talk about any of these issues in more detail, we hope you will. And then before we close off, I just want to let you know about our next webinar. It's always free. We're going to be going over some of the top pathology coding errors and how to avoid them. We have some case studies to represent where we're going to show how some labs are able to regain hundreds of thousands of dollars by just correcting some of these coding errors. And we're going to hit the highlights on some of the more common ones. So if you'd like to register for that now, that's also on your screen. You can go ahead and sign up. We do cap the number of seats at 500. We have hit that on a few of our last few webinars. And so we do encourage you to register early to ensure yourself a seat for that. Thank you always from Lighthouse for attending. Thank you, Robinson Cole, Les, and Danielle for spending your time putting this together and presenting it. And we're hoping everybody out there that attended has a great day. Thanks all.